Now we have almost finished with the general introduction of this course, of these lectures, but we have a remaining point we must yet address. It is a point which I've called in the general introduction the origin of the philosophy of law. This is a point I guess we didn't address yet, and I have to do so today. And then we will start with the remaining of the course. We will end the introduction and we start with the remaining of the course. Now, the origin of the philosophy of law. You remember that in Descartes 3, there is no branches which is dedicated to philosophy of law. So it means that during a long time, the philosophers didn't think that philosophy of law is something apart in the global philosophy. They included philosophy of law in moral philosophy. Most of the thinkers. Of course, there were philosophers who were not interested at all in philosophy of law, like, for instance, the cynicism. I told you about the cynicism before, I guess. There were people in Greece who were, let's say, asocial. So they don't mix with the rest of the citizens. They one lived in a barrel, you know, Diogenes, and they were not interested with the law at all because they thought law was only convention, and what should be respected was nature and not convention or law. So there are some philosophies which are not interested with the law at all. And these are often philosophies of the Hellenistic period of Greece, because during the Hellenistic period of Greece, the philosophies were turned to the individual wisdom. So the philosophers of this period were often, not always, but often not interested in law, but only in individual wisdom, like the cynists. The cynicism is a very good example of this. The cynists, they thought that wisdom was to exercise oneself and to practice virtue, and not to make speeches about virtue, but to practice it. And they thought that law was only the reflection of convention, and there was nothing like just by itself. So they were not interested in the law because they thought the path of wisdom was not to be found in law. Now, most of the philosophies, even in Greek times, were interested in law, but they didn't approach the problem of law separately than the problem of moral. There are a lot of philosophies like this. Let's say, for instance, Plato, which is the most famous philosopher. He thought that justice, individual justice, and social justice was just the same. To be virtuous and to be a citizen who lives in a just city was just the same. He didn't make any difference between justice as social virtue and justice as individual virtue. he made a complete confusion between justice as a virtue and justice as the aim or the goal of the law. There was not any difference according to him, because he thought there could be justice in the city only if the citizens are just, are virtuous. And this is a point of view which lasted well after Plato died. In modern times, for instance, if we take the supporters of natural law, like Grotius, Pufendorf, on the one hand, and the supporters of positivism, of legal positivism, like Hobbes, on the other hand, they are much different one from each other, but they have something in common. They don't think that there is something different between law and virtue. If we take the school of natural law, so the prominent thinkers of this school are Grotius and Pufendorf. They say what is important, what is the real law is not positive law, it is natural law. And what is natural law? Natural law is only moral precepts. Don't harm the other, respect your promises, respect the property. These are orders you can find in the Decalogue. So they thought that natural law is just moral precepts which we as humans can discover by using our reason. So there is a complete confusion between law and moral in the school of natural law. But let's take now the supporter of legal positivism. The most important of them is Hobbes, Thomas Hobbes, English philosophers about whom I spoke before. You remember that Hobbes makes a difference between law of nature, right of nature, and civil law. So according to Hobbes, right of nature is just liberty. Do what you want. Do what is in your own interest. If you have to kill or to steal somebody to get what is you want, there's no problem. This is right of nature. Now, law of nature explains Hobbes in the 14th and the 15th chapter of Leviathan, maybe the 70th. I don't remember. I have not. I didn't bring Leviathan with me. So I speak only with my memory. But it was between the 15th and the 17th chapter of the Leviathan. He explains that laws of nature, they are just moral precepts. And he writes that all these laws of nature can be summed up. Sorry. Hello. 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 This is like my sister. She speaks about much better English than me. She says, hello. When you phone to her. Hello. And my son, he lives in Germany. So, hallo, wie geht's? Okay. My wife is Polish, as a Czech. Hello, Czech. So, what I was speaking about. I was speaking about Hobbes. So, right of nature, this is just liberty. Liberty to do anything you want. And this leads to war because the man is a wolf to the other man, to the others. So law of nature, explains Hobbes, these are moral precepts, moral rules, which can be summed up, summing up, you know, the book of Somerset Maugham, the summing up, the bilan, résumé. Moral law of nature can be summed up in one precept: don't do to others what you wouldn't like to be done to you. Don't do to others what you don't want to be done to you. These are moral precepts. So he says, law of nature are moral precepts. Unfortunately, in the state of nature, the people do not respect the law of nature. The law of nature to be effective, they must be taken in account by the civil law. It's only if there is civil law that there will be security and safety. So the law of nature doesn't exist, is not effective until its content is included in a civil law, in a positive law, if you like better. So Hobbes is in the very opposite with the school of nature, of law of nature. It's just the opposite. He thinks there is no law except the civil law. But the civil law and the law of nature contain each other. They contain each other, but the law of nature is not effective until a civil law contains it. So they are coextensive, one to the other, but the natural law can be only effective in a civil state, not in the state of nature. So this is very different from the school of the law of nature, but there is one point in common. They have one point in common. They don't see any difference between moral and law. Because in Hobbes, the civil law has the task to take into account the law of nature, which are moral precepts. So if we take Hobbes, which is very different from the school of nature, of law of nature, sorry, which is who is very different from Grotius or Pufendorf, we have nevertheless the same idea that moral and right, moral and law contain each other. Now, and we could speak about Leibniz, for instance, or we could speak about Wolff, sorry. We could speak about Spinoza and other philosophers. They share this view. They share this view. But law and moral are contained in each other. I'm not, I haven't read all I should read, but I know there are two philosophers which has made a difference between law and moral. So I guess they are very important in philosophy of law because they are these two philosophers. If we take Descartes three, sorry, they think there is a branch which is philosophy of law, which is different from the branch of philosophy, of moral philosophy. And these two thinkers are, on the one hand, Aristotle, and on the other hand, Kant. So they don't follow the same path. These are two different philosophers. So let's take at first Aristotle, and then we will try to speak about Kant, but Kant is very difficult, so I don't know if I will manage to explain you in a way you will understand, but I endeavor to do so. So Aristotle didn't write any book about philosophy of law. At the time of Aristotle, the philosophy would embrace all the fields of knowledge. So he wrote a book which is called Physics. He wrote a book about logic. He wrote a book about poetry, about rhetoric. He wrote a book, several books, let's say, which had no titles. And then one of the scholars of its school, Andronikos of Rhodes, gave the title Metaphysic, okay? And he wrote books about moral philosophy, which titles are Ethic, Nicomachean Ethic, Eudeme Ethic. So when he speaks about law, he speaks about law, about right, in a book which is dedicated to moral, to ethic. The book in which he speaks the most about justice and law, it is the Nicomachean Ethic. Nicomache was was Aristotle's son. So in this book, it's a book about virtues. Aristotle explains that he's going to look for a definition of virtue and to treat about the different virtues. And then he takes the virtues one after the other, and he explains in which the virtues consist. But before, he had given a definition of virtue. I'm not going to expand on Aristotle's definition of virtue. This is not the way, but he's not only describing virtues. Now, in the fifth book of Nicomachean Ethic, Aristotle expands on justice. Justice is one of the moral virtues he has identified. So he's going to speak about justice as a moral virtue. But if we read carefully the fifth book of the Nicomachean Ethics, we discover that he gave a definition of justice which allows to separate law and moral. Because in the beginning of his fifth book, Aristotle says, well, justice, but I told you about this, no? Justice has several meanings, no? It's just like the shoulder and the key. I didn't speak about this. So he says justice can be understood in several meanings. He says it's just like no. Just like the word clays. Clays in Greek, it means the key with which you open the door, but it means also the bone of the shoulder, clavicule. So he says, Aristotle says, there are words in Greek which have several meanings. For instance, clays, it means the key, but it means also the bone of the shoulder. I don't know the name exactly in English. Clavicule, we say in French. Here there is a bone. You can break it, you know. Now he says justice is not like clays because it has several meanings, but these meanings are related one to the other. They are somewhat related to one to the other. But nevertheless, there are several meanings. And he says justice, the concept of justice can be divided in two meanings. First meaning of justice, it is universal, general justice. Universal general justice is, says Aristotle, it is the total virtue, the complete virtue. And now, when he writes this, Aristotle thinks probably about Plato. He probably thinks about Plato because Plato in the Republic, the state, I don't know, we say Republic, I guess, in English. In the Republic, Plato wrote, well, Socrates says, but Plato wrote that justice is the most fundamental virtue. The virtue which allows all the other virtues to exist. So if in a state there is justice, there are also the other virtues. So he says the justice is the most fundamental virtue, which allows the other virtue to be born and to exist. That's what Plato wrote in the fourth book of the Republic. So when Aristotle says justice can be understood as the complete virtue, the total virtue, he thinks about the justice as it was defined by Plato in the Republic. But Aristotle adds there is another sense of justice, which is not universal, which describes the specific virtue of justice. Justice as a particular specific virtue. And Aristotle says, well, I'm going to deal with this specific justice and not with global virtue. Because virtue I have previously defined, and now I'm describing the different virtues. So if I want to speak about justice, I have to speak about justice as a peculiar, as a specific virtue, and not justice as the whole virtue like Plato did. And what is justice as a specific virtue, a peculiar virtue? Aristotle says it is equality. So he is not writing a treatise about philosophy of law. This is very clear. But he suggests a definition of justice from which we can separate law and moral. Because he says justice in a peculiar sense, it means equality. It doesn't mean we are going to to see if the people are just or not, if they have a virtue in themselves, which is justice, we are going to see if in the relation one to the other, there is some equality which will be respected. And he say more precisely, but I'm not going to develop this point. I'm not going to expand to this point because I have a hope to speak about Aristotle more in details in the future. But this is just a hope, inshallah. It depends on how fast I'm going to give these lectures. So, but I'm going to just to give you some elements very quickly because it will remind you things you probably already learned in law lectures. He says that this justice, in a peculiar sense, the specific justice, divides itself between two kinds: distributive justice and corrective justice. Corrective, there is another word in English. I forgot it. They don't say corrective justice in English, they say, just a minute. I have to look on Google. They don't say corrective justice. In the English translation of Nicomachean Ethic, they give another word. Yeah. Restorative justice, that seems to be a little. I see collective justice here, but it seems to me strange. It seems that they use this word, collective justice, but I guess there is another word which is used in English translations of the Nicomachean Ethic, but I don't remember it. Anyway, distributive justice, this is used in English translations. And with French, we say corrective justice. The corrective justice is it's a justice which will, let's say, reestablish something. For instance, if you inflict some damages to anybody else, you have to repair. This is corrective justice. So distributive justice for Aristotle, it is the justice which distributes all the things which we have in a city: the honors, the jobs, the taxes, and all this. This is distributive justice. So when you distribute between the citizens, among the citizens, you have to respect justice. Now, what is the criterion of distributive justice? It depends on the regime. For instance, the criterion is different in a democracy, in an aristocracy, or in an oligarchy. But he says it depends on the regime, of course, but there must be some distributive justice. Because if there is no distributive justice, this is tyranny. Now, he says in the justice in the specific sense, there is distributive justice, but there is also collective justice, and collective justice, it's not in the relation of the citizen with the state, it is in the relation of the citizens between them. The citizens have relations, voluntary or involuntary. If they want to have relations, this is a covenant. If they didn't think about relations, these are torts and damages. And he says, either in covenants or in torts, there must be a corrective justice which is respected. So if there is damage which is inflicted either in a covenant or in a tort without covenant, you have to reestablish a certain equality. And this is corrective justice. This is vague. I acknowledge this is vague. I'm not going to expand on Aristotle now. But you can understand now that there is in this fifth book of Nicomachean Ethic there is a try from Aristotle to isolate the problem of law of the problem of moral. Equality, which must be respected in distributive justice and in corrective justice, is something different than to be virtuous, to be moral. So in Aristotle, in the Greek times, there is for the first time a philosopher who will distinguish more or less moral and law. And even if he doesn't make it explicitly, because his book is a book of moral, Nicomachean Ethics. In the fifth book of this treatise, you have elements of a distinction between moral and law. That's why the lawyers are very happy with Aristotle, and they are always quoting Aristotle. Well, I didn't read Plato, but Aristotle, yes, because in Aristotle they have a justification of their field of work. They have a justification. They are not under the dependence of moral philosophy. They have a discipline which is independent from moral. So they are very pleased with Aristotle, of course. Even if they didn't understand Aristotle, this is another problem. If you don't read Greek, you cannot understand Aristotle, I guess. Too complicated. Now, there is a second philosopher who followed another path and endeavored to distinguish moral and law, but this time formally, not implicitly like Aristotle. And this second philosopher, it is Kant. There are some philosophers in the history of thought who are turning points. Yes, Plato is a turning point. Socrates is a turning point. Kant is a point. It's a very important thing. Now it's going to be difficult, so I'm going to simplify, and I don't know if I will succeed. I try. I make my possible. I do my possible, sorry. In the beginning, Kant was not interested with the law. He didn't pay attention with the legal problems. So in his moral books, moral books. This is, for instance, the critique of the practical reason. And the fundaments of, how we say in English, fundaments of foundations of the metaphysics of morals. This is not the exact translations. This is an adaptation. This is not the exact translation of the German title. Foundations of the metaphysics of morals. Groundwork of the metaphysics of morals. Another title I see. Groundwork of the metaphysics of morals. This is a better title. Because foundations, it seems strange, because foundation, this is a foundation of a house, you know? And but the German word is Grundlegung. Grundlegung, it means something which is in the ground, which is stick in the ground. Yes, Grundlegung, also groundworks. Okay, but this is important that groundwork is in singular. It's not a plural, it's a singular. And that's very important because foundations in plural, or fondement in French we say fondement in plural. This is not accurate because there is only one fundament, one ground of moral, and it is the autonomy of the will. So to say there are foundations in plural term, this is not accurate. It can lead to mistakes. So one moral work of Kant's moral work, this is groundwork of the metaphysics of morals. Another moral work which Kant wrote afterwards is the critique of the practical reason. He wrote a critique of the pure reason, and then he wrote a critique of the practical reason. These are two different books. Now, what he wrote in the groundwork of the metaphysics of morals, and what he wrote in the critique of practical reason, it is that morality is not legality. Morality and legality are two things different. And what is important, writes Kant, it is morality, not legality. Let's give an example, which can be found either in the groundwork of the metaphysics of moral or in the critique of practical reason. Let's take an example. You borrowed something to somebody else. This thing you borrow, you have to render, okay? So if you render this thing, this object you borrowed, because you fear that you could be punished or that you could be criticized. Of course, you are you are obeying to your duty. You are obeying to your duty. You have a duty to give back, to render this thing. That's okay. But according to Kant, this doesn't mean anything about moral, because you just render the object because you fear to be punished or to be criticized by the others who say, look, this guy, he borrows things and he doesn't give them back. He's not a fine guy, he's just a crook. Huh? Or you could be punished, the court, you could be in court and you have to give it back, and you give you have a sentence against you. So Kant say, if you give back, you render what you borrowed, but because of the fear of a punishment or social disapprobation, this is not morality. This is just to respect the duty, but you respect the duty not because you want to respect the duty, but because you have not another choice. And Kant says this is legality, lawfulness, if you like better. Now, morality is something else. Morality, it means that you are going to accomplish your duty because it is your duty, and only because it is your duty. In other terms, the motive of your action must be the respect of the duty and nothing else. This is what Kant calls categorical imperative. Maybe you heard about this. Categorical imperative. It means the reason commands to the will to observe the moral law, the duty, only because it is the duty and not for another reason. The motive of the man, let's say the man, it's not the word Kant uses, but anyway, the motive of the one who accomplishes his duty must be the duty by itself. Now, how can we be sure that somebody accomplish his duty only because it is the duty? The fact is, we don't know if it does exist. And as Kant wrote in the groundworks, maybe there was never any moral action in the empirical world. It's possible that it didn't occur. But this is not my problem, because what I'm trying to do is to establish the foundation, the groundwork of metaphysics of morals. I'm not checking if they exist in the empirical world, a moral action. This is not my problem. I just explain in to which condition an action can be moral. And a moral action is not a legal action. Legality, lawfulness, and morality are two things different. Now, what is the condition for what is the condition for will to be moral, to follow only the duty because it is the duty? The condition, and this is the discover, Kant's discover, very important discover, he say there must be an autonomy of the will, an autonomy of the will. So I guess you didn't make any, didn't study Greek, except the students are from Greece, but the other are not. So autonomy in Greek is two words, autos, And autos, it means itself. And nomos, you know, or nomos, you all know nomos, this is law. And autonomy, it means that the will gives to itself its law. So how can we be sure that will obey the duty, the moral law, because it is the moral law, because it is the duty, and not for another consideration? It's only possible if the will gives itself the law. So the will must be submitted to the moral law, but it must be also a lawgiver, a lawmaker. So it's only if the will derives from the will, it's only if the law, the moral law, derives from the will, that the will obey to the law only because it is the law. This is the autonomy of the will in Kant's thought. Because if the will submits itself to the law which is imposed by somebody else, by the court, or by the religion, or by the social reprobation, it means that the will not accomplish its duty because it is the duty. It will accomplish the duty because of something else. So if we want the will to be moral, it means that it must submit to the law which it gives to itself. This is the autonomy of the will. And this is the great Kant discovery in the field of moral philosophy. Now, what does it mean that the will is autonomous, that there is an autonomy of the will? It means that the will is free. If the will obeys only to the law it gave itself, it means that the will is free. It's not submitted to the law, it's submitted to the law which it has itself given. So it means that the will is free. This is how Kant thinks the moral problem must be resolved. So what is very important at this time, Kant spoke about legality, about lawfulness, only to explain that lawfulness is not morality. Lawfulness is bad. It must not be considered because it's not moral. So at this time, when Kant wrote the groundwork, of the metaphysics of moral, when he wrote the Critique of Practical Reason, this is 1788, he didn't think about law. He was not interested in law. But progressively, later, well, when he wrote the Critique of Practical Reason, he was already 65. But he had still a path to follow, and he understood progressively that there must be in his philosophy a place to the philosophy of law as something different from the moral philosophy. And this we are going to explain after the break. You didn't understand anything, did you? You sure understood? This was very simplified, because if I'm going to explain Kant, we are going to spend the 24 hours on Kant, and this I cannot do. but I must give you some elements because I think he's very important in the field of philosophy of law. So I'm trying to end after the break. You're sure you understood something, despite my accent? Okay, 10 minutes break. Now I'm going to try to speak slowly. How Kant was led to the conclusion that the law is something important. The law as the right is something important. Although he wrote at the beginning that the morality is only what is important and legality, lawfulness, has no importance. How he was led to change his mind. Change his mind is a little excessive. It's not really change his mind, but he makes some evolution. Now, what he wrote very early in the Critique of the Pure Reason, there is in the Critique of the Pure Reason a chapter which title is Canon of the Pure Reason. Canon of the Pure Reason. Canon. This is not to throw shells. It's a canon. This is principles. Principles. So this is a very old part of the Critique of the Pure Reason, because the Critique of the Pure Reason, he didn't write it in a week, within a week, because it has 600 pages. So he had to write it in a lot of years. He was already 55 when he published the Critique of the Pure Reason. So in this chapter, which is called Canon of Pure Reason, Kant explains, well, let's simplify a lot. Kant explained that morality is not enough, because if you act morally, suppose it's possible, if you act morally, but you have not a hope in a world which will be better, you are going to fall in despair. What is the use to be moral? What is morality if there is not something in which we can hope a better world, a moral world? It doesn't mean that when you are acting, you must act in consideration of a name, which will be a better word. This is not this, because Kant insists that morality is not related to a goal which is external to morality. Morality, it means to obey to your moral duty only because it is the moral duty. This is the autonomy of the will. But anyhow, however, even if morality cannot aim to happiness, morality cannot aim to happiness because the fundament of morality is not happiness. The Greeks, they thought that morality is aimed to happiness. When the Greeks speaks about virtue, they speak always about virtue in relation to happiness. If you have virtue, you get happiness. But Kant says this is a mistake. This is a mistake. The morality has nothing to do with happiness. There is nothing like hedonism. So morality must be founded in itself by the autonomy of the will and is independent to happiness. But however, if you act morally, if you follow your duty, and if there is no hope that there will be a better world, if you have no hope at all, you are going to fall in despair. So there is a question which is important in philosophy. It is, what must I do? What must I do? But there is a second question in philosophy. You cannot hide, you cannot live aside. And this second question, well, there are three questions. In the canon of pure reason, there are three questions. First question, what can I know? What can I know? And the answer, it is the critique of the pure reason. But this I'm not going to develop. What can I know? With the while using my reason, which knowledge can I reach? The second question, says Kant, it is, what must I do? The first question is a question of knowledge, of Wissen in German. The second question, it is a question of practice, of action, tun in German. What must I do? And now there is a third question, which exists in any philosophy, says Kant, and it is, what can I hope? What may I hope? Let's say, let's try to translate German. What may I hope? If I know what I can know, if I act as I must act, what is the hope? What can I hope? What may I hope? And now you have to have a hope, because if there is no hope, you are going to fall in despair. So, of course, happiness, it is not the aim of moral. But there must be some hope, not assurance, but a hope that happiness, a better world, will follow acting morally. That's what Kant wrote already, wrote in the Critique of the Pure Reason. Now, what he thought later, it was that a way to reach to have an hope to a better world. It's not a certainty, it's not an assurance, it's just a hope. But a way to hope to get to a better world, it is law, he says. Of course, if the world is a world of law, of right, it doesn't mean that the people will be morally better. Because I remember you that morality for Kant is something different from lawfulness or legality. The people are not going to be better, morally speaking, if they obey the law. But it's a way to get a progress in the world, because in the world, if the relation between humankind, the relation in humankind, it's a relation of law, of right, and not a relation of violence, of fraud, of war, this is already a progress. Of course, the people won't be better morally speaking, but they have made a progress. If we live in a world where there won't be any war, neither inside the states or in international relations. This is a path to a better world. So we must try to enforce the law in the international relations, in the internal relations of states and in the international relations. We must enforce the law so that the world will be better to live. It doesn't mean there will be a progress of morality, but a progress of lawfulness, of legality, is just a way to get to a better world. We can hope in a better world only if we reach the state in which the law prevails against violence, against war, and against fraud. And Kant, maybe you know, he wrote a very famous essay, which title is Towards Perpetual Peace. I guess this is the English title, Towards Perpetual Peace, Vers la paix perpétuelle, zur ewigen Frieden, Towards Perpetual Peace. It's an essay in which he describes the conditions and the clauses of an international treaty which will implement the peace in the world. And he explains how this peace in the world can prevail. Of course, he wrote before Hitler and before Putin. Maybe he wouldn't write this essay if he lived in the times of Hitler or in the times of Putin. I don't know. But that was his hope. He didn't say it was a certainty, but he says it is a hope, and there are some there is some grounds to have this hope. Now, it appears to Kant that law is something important. Because it's the first step to a better world. It's the first step before morality. And then, therefore, law must be taken in account. That's why he was led to his philosophy of law by his philosophy of history. Because he dealt with the problem of progress in humankind, he was led to think that philosophy of law, that law is something important besides moral. And that's why when he wrote his moral treatise, he divided them in two parts. philosophy of law and philosophy of virtue. Metaphysics of law or metaphysics of right. I don't know how it is translated in English because we have always a problem with law and right in English. Let's say metaphysics of right on one side and metaphysics of virtue on the other side. So he says in practical philosophy, moral philosophy in a wide sense, there are two parts which must be explained: the metaphysics of rights and the metaphysics of virtue. So he made formally a distinction, between the two fields of the moral, between the philosophy of right, the metaphysics of right. Metaphysics in Kant's language, metaphysics is the same than philosophy. Metaphysics of right on the one hand, and metaphysics of virtue in the other hand. Now, how does Kant distinguish the concept of right, of law, and the concept of virtue? Well, because there must be a difference between them if there are two separate treaties about each other. So you remember when we started these lectures, we spoke about the question, what is right, which is in the metaphysics, the principal metaphysics of right. We spoke about this question. What is right? But we didn't explain the answer to this question. We said only that Kant distinguished two questions in the first metaphysical principles of right, of the doctrine of right, first metaphysical principles of the doctrine of right. This is the exact translation of the accurate translation of the German title. He says there are two questions that should be distinguished. The question, what is law? The question, what is law? What is right? This is a philosophical question to which the lawyer is not entitled to answer. And the question, what is lawful? To which the lawyer is entitled to answer. I think I explained this to you before. Now, what I didn't explain you, I explained you the meaning of the two questions, but I didn't explain you the answer that Kant gave to the question, what is right? And the concept of right must be something different than the concept of virtue. But until he wrote the first metaphysical principles of the doctrine of right, Kant didn't define the right, didn't define the law, because what he wrote before, it was that legality is not morality, lawfulness is not morality, and legality, lawfulness is bad, okay? Now he has to deal with legality, with lawfulness. He has to say it's something fine, no? So he has to accept the concept of right. He had to explain it. So he says that the right should be, generally speaking, defined as following. The right, it is the conditions by which the free will of one, can accord, can accord to the free will of another. It supposes the concept of law implies, the concept of right, of law implies that there are free wills which must be in accordance one to the other. This is the definition of right. Now, why Kant gives this definition of right? Why right is the accordance of free wills? Because what Kant explained before in his moral philosophy, it is that the will is free, okay? If the will is not free, you cannot say an action is moral. I mean, if you give back an object which you borrowed because you are forced to do so, there is no place to morality. The morality, it means that you have to give back something you borrow. You can give it back, or you can not give it back. You can keep it or give it back, okay? And what is moral? If it is that you freely give back what you borrow. This is morality. If you had not any choice, if you hadn't any choice, if you were constrained to give back what you borrowed, it doesn't imply anything in a moral point of view. The action to be moral needs that you are free to give what you borrowed back or to keep it, but you choose to give it back. This is moral imputation. Now, this is, yes?
What if I feel like it's the right thing to give back the object, but you also there is no choice for you to do so? Is it moral to give the object back in that case?
If you have no choice?
If you have no choice, but you also feel like it's the right thing to do from within yourself.
This is a good question, and the answer is the concept of right in Kant's thought. So I'm going to endeavor to explain, and if you are not satisfied with my explanation, you just ask once again, okay? So, what says Kant? It is the following. So, right must deal with free will, because there is no imputation, no moral imputation, but also not lawful imputation if somebody is not free. For instance, you cannot reproach in the law to somebody to keep what he borrowed instead of giving it back if this guy is crazy, or if it is a little child. This is moral imputation. You must have reason. So reason, it means that you have a free will either to respect your moral duty or not to respect it. And this is true as well in the moral field and in the legal field. So the right, the law, deals with people which are reasonable, which have reason and free will. And what is the aim of the right, of the law? It is to do so that the will of one man must be according to the will of the second. of the others. And this is law. This is right. And the free will of one must be accord to the free will of the other. And why the free will? Because without free will, there is no duty and no imputation. And this is true in morality, but in legality too. Now, Kant says the difference between morality and legality, it is that in morality, you must take the moral law as the aim of your action, as the main of your action. This is the moral law. It is because it is the moral law that you do this action. This is morality. It is because it is your duty that you make your duty. The duty is the motive of your action. This is morality. Legality, right, prescribes to do an action without considering whether you are going to make this action because it's your duty or for another reason. It is not in the power of the right to make you it's not in the power of the right to oblige you to accomplish a moral action because it is your duty. The right has nothing to do with the motives. The right is an external law which compels you to observe your moral duty, but cannot determine you to observe your moral duty because it is your moral duty. This is impossible. Because the external law, the right, has no power to determine you to accomplish your moral duty because it's moral duty. It has no power on your motives, on your motives, yes, on your maxims of thinking. So this is the difference between right and morality. In virtue, in morality, you obey your duty, the moral law, because it is the moral law, and this is the motive of your action. That's why morality supposes the autonomy of the will, because you are going to obey the law, the moral law, because it is the moral law, only because your will is free and autonomous, only because the will gives itself the law to which it will comply. But in the concept of right, the right prescribes you to obey your moral duty, but cannot oblige you, compel you to obey your moral duty because it is a moral duty. It compels you to do your moral duty because if you don't do this, you will be punished. Right is related to compelling. You oblige somebody in an external sense, you compel him to do something. Law is something internal. It is in your mind, moral, it's internal, it's in your mind. So in moral, you act in accordance to your duty because it is your duty and not for something else. In right, you do your duty because you are compelled to do it. For if you don't do your duty, you don't make your duty, you will be punished. So law, right, can be defined as the conditions to which the free will of somebody is in accordance with the free will of the others, but in order that the free will of somebody is in accordance with the free will of the others, you must compel the people. You must oblige them. So right is related to compelling, to compelling. This is the way he distinguishes right and virtue. Virtue has something to do with the mind. You have to obey the moral duty because it is your moral duty, and this must be your motive. But right has not this power. He cannot compel, right cannot compel you to obey, to respect your moral duty because it's a moral duty. It compels you to respect the moral duty because if you don't do so, you'll be compelled to do it. You'll be constrained to do it. That's all. And this is the origin of the very classical and famous distinction all the lawyers make between morality and law and right. They say always at the beginning of the law lectures in the first year of your studying, they say, well, moral is something, it has something we do with it's an internal matter. And law, right, it is external matter. This is very classical distinction. But this distinction, it is Kant who formalized it and built it. Before Kant, it was not so clear. And that's why in the history of philosophy, besides Aristotle, and following another way, can be regarded as one of the philosophers who distinguish moral and right. And he was the first in the history of thought who dedicated one of his work to the specific problem of the law of the right. Because formally in Kant's work, there is a treatise which is called First Metaphysical Principle of Philosophy of Law, of Doctrine of Law. First Metaphysical Principle of Doctrine of Law. So he didn't say philosophy of law, he said metaphysics of right, okay? But this was the first time a philosopher says, look, there is two different problems, the moral problem and the problem of law and right. And even if these two problems are related one to the other, we must distinguish them because there is a specificity of the law, of the right, which implies it cannot be reduced only to a moral problem or virtue problem. Now, the title Philosophy of Right, Philosophy of Law, Kant didn't use this title. He spoke about the principles, metaphysical principles of right, but you know that 30 years later was the first principle of metaphysics of the doctrine of right would be written in 1794. Kant was already 75 or 76. And more than 30 years later, less than 20 years later, in 1821, Hegel wrote his book, Principles of Philosophy of Right. Hegel was the first to use the expression philosophy of right or philosophy of law, depends on the way you translate the German title. But if he was the first to use formally this expression, one might say that in the modern philosophy, Kant was the first to distinguish the two problems. These two problems were confused, were considered as the same problem by Hobbes, Locke. I didn't speak about Locke. I didn't speak about Locke earlier, but Locke is just like Hobbes in this point. Locke doesn't make any distinction between moral and law, between moral and right. So in the modern philosophy, there was no distinction before Kant between moral philosophy and philosophy of right. That's why can be regarded as a turning point in the history of philosophy of right or in the history of philosophy of law. Now I think I've finished with this general introduction to the lectures. Did I answer to your question or not? If not, you can explain it better now. Sorry?
More clear.
Are you sure it's very clear?
It's a complicated subject, but I think it's more clear now, yes, for sure.
Well, thanks. The problem is Kant is a very complicated thinker.
Yeah.
And since I have only 24 hours of lectures, I cannot explain Kant as I should explain him in order that you could understand his thoughts. Because you must understand that the philosophy of right in Kant's works is just a part of a global work. And if you didn't, if I don't explain you the critique of the pure reason, the critique of the practical reason, and all the works before, I can only give you a glance about the philosophy of right of Kant's philosophy of right, but I have to avoid many problems and simplify many matters.
I'll read it.
The critical of the pure reason.
Rest.
Critical of pure reason, it's already it's 3 years of work. Just read the critical of pure reason. This is 3 years. Okay. I can tell you, even in English translation.
Yeah.
I know because I did it. So Kant, this is a philosopher that who needs many years to be understood. And even when you know Kant and you want to explain it, I did the experience on Monday in the philosophy of law. I have lectures in French, so it's easier for me. It should be easier for me. And I tried to explain something about Kant, and I felt that the students they didn't plainly understood. And I have to come back to get back to this problem because I'm not satisfied with the explanations I gave. Although I know Kant, I can say I know Kant. I didn't read a passage about Kant. No. I know Kant in French, I know Kant in German, so it's a philosopher on who I studied a lot, but it still is very difficult. But it's worth studying it. If in the future, if you study philosophy of law, you cannot avoid to study Kant to get a deeper knowledge of Kant than the knowledge I gave you in these lectures. This is very important in philosophy of law. Now, any question about general introduction? You have still no written lectures. but I hope I get them, but I must correct and correct every week. So it's a matter of time, okay? But you have the records of the lectures. Now, these lectures will be divided in 3 parts, but we are not going to treat the 3 parts because we haven't enough time left. So the first part, the part 1, I gave the following title: Greek philosophy, 2 points. How we say in 2 points? Greek philosophy, 2 points: nature, law, and justice. This is the first part of these lectures. So we're going to speak about Greek philosophy. Sorry, guys, but we have to do. Now, the second part, which I'm afraid we will not have the time to treat, to expand about. I give you, nevertheless, the title: Modern Philosophy. But I gave you a glance about Kant. So, modern philosophy, law of nature, social contract, civil law. Wait, social contract, sorry. Law of nature, social contract, civil law, contract, covenant. Huh? Law of nature, social contract, civil law. And in this second part, which we will not have the time to expound, we should have spoken about Hobbes, Locke, Hume, and the school of natural law. All these thinkers are very different one from each other, but they share some problematics, like the law of nature, the question of the law of nature, the question of the social contract, which is the fundament of the civil state, and the question of the civil law and its relation to the law of nature. And the third part of these lectures would have been dedicated to Kant's philosophy of law. So I gave you just a glance, but if I wanted to explain it, I would have need to get some 20 hours about it. So I have not these 20 hours. So that's why I give you a glance just now about Kant. Now, we start today with the first part, part 1, Greek philosophy, 2 points, nature, law, and justice. Now, there is something important in Greek democracy. So we speak about Athens, because there was no democracy in every Greek city. For instance, in Sparta, it was not a democracy, it was an oligarchy. So when I speak about the Greek word, I speak mainly about Athens. So in Athens, it was a direct democracy. And it means that every citizen played a role in the city. So the discussion about law and politics was the business of everyone, or every citizen, because most of the inhabitants of Athens were not citizens. They were slaves or metek. Metek, it was the people who were born elsewhere than Athens, and they hadn't the same rights than the citizens. So the citizens was a minority. well, it was actually a minority, but these people, they participated in the political life directly. This was a direct democracy, not like today. We have a parliament, we just elect deputies, but we have not many ways to express ourselves directly, except in social networks or in referendum. But the people are speaking for us, the deputies are speaking for us. But in Greek democracy, it was something else. It was direct democracy, and the citizens were supposed to participate to the power directly in the boule. It was the parliament of Athens. It was called the boule. The boule is the place where you deliberate. This is the meaning in Greek. So, and every citizen was due to participate to the boule at one time of his life. So politics and law was a matter of everyone. That's why if we study Greek literature, we see that the matters of politics and law are not only the field of philosophers. There are a lot of writers, thinkers who are dealing with these problems. There are, for instance, the orators like Demosthenes or Isocrates, Lysias. They speak about politics and law. You have the tragedians like Aeschylus, we say in English, I think, Sophocles or Euripides. They wrote pieces of theater, but they spoke about these problems in their pieces. You have the historians like Thucydides or Xenophon, sorry. So they deal with politics and law problems and legal problems. And now there are, of course, the philosophers. In the classical times of Athens, before the Hellenistic period, you know, the Hellenistic period, it is the period, Hellenistic time, sorry, it is the time who begins with the death of Alexander the Great. It means in 323 before Christus. And this time of Greek history, it is a time where there is no cities as political entity left. So Athens has lost its independence, and the other Greek cities also. So it's not a time, the Hellenistic philosophy, in which the philosophers are dealing with so much with politics and law, because it's a time where the philosophies are aimed to individual wisdom instead of dealing with political matters. Why? Because there are no more cities as political entities. There is only an empire, the empire of Alexander the Great's empire, and the empire was divided after Alexander's death between his generals. So this part of Greek history, it is a part of Greek history which is called Hellenistic time. And in Hellenistic times, there were many philosophers but they dealt mainly, not exclusively, but mainly with individual wisdom. And a good example, it is the cynicism about which I told you before. I don't say that all the philosophers of the Hellenistic philosophy are indifferent, don't take care about, don't pay attention to the city and the political matters. But the main goal they try to achieve, it is individual wisdom. You know, there is a, I'm going to end with this, the Stoics, you heard about the Stoics, Stoicism. They say philosophy is just like an egg. You have, how you say cookie in English? The cover of the egg. Shelter, yeah? Shelt? Shell? Right, the shell, yes. The shell of the egg, this is logic. The white, it is physics. No, sorry. The shell, it is physics. No, the shell is logic. Anyhow, it doesn't matter. The shell is logic. The white is physics. And the yellow, it is moral. But the yellow is at the heart of the egg, you know. And the philosopher is just like somebody who is in his shell. He's in his shell. He protects himself. So he is not interested with the outside world. This is just an image, but it's significant, you know. It means that Hellenistic philosophy, Stoicism was a very important Hellenistic philosophy, deals rather with the individual wisdom than with the happiness of the city. But this was in Hellenistic times. But before, in classical times, I mean the 5th and the beginning of the 4th century before Christus, law and politics was a problem for all the philosophers. Now, now it's time to stop. So I would tell you something funny, but next time. Next time. You must not fancy, you must fancy that Greek, it was that Athens, it was a place where there was only intellectuals, there were only intellectuals we were speaking about law, philosophy, and like this. Most of the people, most of the citizens, they were busy with trying to earn money and to survive, you know, to make trade, to sell things, or to be farmers. So the citizens who were speaking about law and politics, it was people who had money and could follow the lessons of the philosophers, the philosopher's lesson. So you must not exaggerate and think that that Athens, that was a very intellectual city where everybody was interested with the ideas of Plato or Socrates or Protagoras. It was not like this. It was only an elite who had the money and the leisure to do so. That's all I wanted to say. So, Locke. So, since my accent is not perfect, as you could have remarked, if you had any questions during the lectures, you have to ask them. For instance, I say contract, and I had to say it 3 times because but I don't say, we don't say contract in English, we say covenants. So contract is not very easy to say in English. So if you have problems due to my poor English accent or to the complicated things we are trying to deal with, you have just to ask questions in English. So laws.
Well, I want to put note of